name is Divinah Ongaki. I'm a lawyer. I'm an advocate of 7 years standing. I am a partner with Agema Analysts, which is a cross-border legal services firm, which means we're based in several countries and we offer legal advice across various jurisdictions. I myself have been practicing in Kenya for 7 years, as I said, across various sectors: real estate, finance, intellectual property law, corporate law, among others. The Sectional Properties Act is a piece of legislation that came into force in December of 2020. It seeks to empower individual owners to have ownership of units individually. What that means is an apartment owner can actually have title to their own apartment as opposed to relying on a sublease. It also empowers the individual owners within an estate to own common property jointly. So the driveways, the staircases, the corridors that form part of a development that can't be owned exclusively by one person because everyone enjoys a right of use, those are owned jointly by all the unit owners within that development. So the Sectional Properties Act is actually coming in to provide a framework where individual owners can actually have titles to apartments or flats or maisonettes in their own right. A sectional property scheme will essentially have the common areas, as I've said. These are the areas that have to be used by everyone, because you can't enjoy your unit without having accessways, without having corridors, without having staircases, the roofs. So those are the common areas in the common property. There are also the units. The units are individually owned by the homeowners. So what that means is your particular apartment, it begins from the floors to the walls to the ceiling. That is your sole property. Everything else outside the unit is not your property. And now the Act empowers the corporation that runs or manages the common areas to enter into arrangements with either third parties or owners of the units themselves, and it allows them to have exclusive use of specific areas. So if one of the owners wants an exclusive use to a garden, there can be an agreement for that. Maybe a common example would be parking bays, because sometimes when you're buying a unit, it's attached to a certain parking bay, and that's exclusively for you. It can't be for anyone else. There is a corporation that is formed under the Act, and by being an owner of a unit, you are automatically incorporated within the corporation. That means you become a member. So any decisions that have to be made, they are made by unanimity. That means you have to all come together to make decisions or pass a resolution that affects the entire development. The difference between the Sublease framework, which we've had in the past, and the Sectional Properties Act framework, which is trying to establish sectional titles, is primarily that under the Sublease framework, a developer would put up an apartment or blocks of apartments and incorporate a management company. Now, as he kept selling off units of his development, he would be allotting shares in the management company to the purchasers. The intent being that after he disposes of all the apartments, he will transfer the land to the management company, so that all homeowners who are shareholders in the management company then become owners of the land by virtue of their shareholding in the management company. There have been issues with the subleasing framework. Now, we have instances where developers don't transfer the land to the management company, or developers stay on in the management company even after they've sold all the units in the estate, with the intent of maybe charging exorbitant service charge. We have had instances where developers close up the companies that own the development before they transfer the title to the management company. So all these kind of scenarios make the subleasing framework very inefficient. The gaps that the Sectional Properties is coming in place to fill are, for example, that The corporation that would be the manager, that would take the place of the management company, it is formed by operation of the law. So it's not a company that actually has to be formed under the Companies Act. Also, membership, as I have said, at the point of lodging the sectional plan, an application for incorporation of the corporation is also lodged. So every owner of the unit is automatically made a member in the corporation. So there are no forms that you need to fill. There's no one who actually has to allot you shares in that company. You automatically become a member. The other thing is that rates and taxes and property charges, they are charged on your individual unit. In the past, or under the subleasing framework, what happened was the members would have to pull together, give monies to the management company, who would then pay the property rates on the entire property. But here, your rates are assessed. Your sectional title is deemed to be a parcel of land on its own, so you pay rates on your title. I would say another key difference would be that because the corporation is formed essentially by operation of the law, there's no filing requirements. So you don't have to go to company's registry every time someone buys a new apartment to go file paperwork at the company's registry, because it's just simply notifying the registrar that this is the new owner of the land. So again, it's a cheaper sort of framework. A sectional title is created by lodging what is called a sectional plan. A sectional plan is a diagrammatical representation of the entire estate. It can be a block drawing that represents maybe all the various buildings on the premises. It sets out the parking areas, the exclusive areas, the driveways. So in essence, it depicts how the development is, including all the units with their floor areas. So once you lodge this sectional plan, you have initiated the process of getting a sectional title. Together with the sectional plan is, as I said, the application for incorporation of the corporation that will actually manage the common areas of the property. Once the application for the corporation together with the sectional plan is lodged, the mother title, that's the main title for the whole project, is actually closed up. So that registers for these individual units. So if there are 20 apartments in a development, each of them will have their own register and each of them will have their own title. We need to engage a surveyor, a licensed surveyor, who draws up the sectional plan. The sectional plan has to be endorsed by the Director of Surveys. It also has to be confirmed by the county government, because at the point of putting up the building plans are usually registered with the county. So county has to give confirmation that the sectional plans are actually an accurate depiction of the building plans that were lodged with them. The Act actually empowers different classes of people to lodge their application for either conversion of a sublease to a sectional title or for the application for sectional title itself. This can be the management company, and the Act actually gives the registrar power to dispense with the production of the original title, because they encompass situations where the developers might be unwilling to actually initiate this process. So it can be initiated by any of those persons I've listed. So generally, the Sectional Properties Act applies to both leasehold and freehold properties. For leaseholds, they have to be over 21 years. Converting subleases to sectional titles, subleases actually have to interrogate their sublease documents, because the Act does not allow conversion in instances where a sublease doesn't provide for transfer or reversion of the land on which the building is erected to either the management company or to the owners itself. So if it wasn't the intention of the developer that this land should ultimately move to the owners of the unit, you can't implement a sectional property scheme. Also, in instances where the properties are of strategic or national importance, then sectional properties can't issue for those areas. When the Act came in place in December of 2020, there was a 2-year period within which conversion should happen. That is, conversion from subleases to sectional titles. However, the impediment has been there were at that time no regulations that would come in place to actually operationalize the provisions of the Act. The regulations themselves came into force in December of 2021. I know that on 10th May 2021, the Ministry of Lands actually gave a communication saying they would discontinue registration of subleases, and there is a deadline for conversion, although it's hard to say whether we will meet it. Ideally, this Sectional Properties Act, it applies to flats, offices, apartments, even maisonettes. There are developments where it's townhouses, but they're in a gated community and they enjoy certain facilities together, and they're all under one parcel of land. So those can be also converted to sectional titles. The exemptions would come in for leases that don't have provisions for transfer of land, as I'd explained. There is a corporation that is formed under Section 17 of the Act. Now, it is formed by operation of the law. Usually when the registrar lodges the sectional plan for the development, he should also lodge, together with that plan, an application for incorporation of the corporation. So the corporation is formed through that application, and all the owners of the units are incorporated as members. The penalties under the Act are as follows. There's a general penalty of 250,000 for anyone who contravenes the Act. There is a very steep penalty for developers, which is 20 million for developers who are selling or renting units that do not have sectional plans registered. So it's really sort of incumbent upon developers to try and conform with the provisions of the Act.